Three state chief judges will in the next few days be required to appear before the National Judicial Council to face disciplinary action for granting conflicting orders on political matters brought before their courts. The decision to investigate the judges was taken by the Chief Justice of Nigeria, Justice Tanko Muhammad, after a meeting with 7 heads of courts on Monday. The chief judges that met with the CJN are those of Rivers, Kebbi, Anambra, Jigawa, Imo, and Cross River states, as well as the Federal Capital Territory. Justice Mohammed last week had invited the chief judges to explain the rationale for the issuance of contradictory court orders by judges in their jurisdictions. The invitation was sequel to an exclusive report by Arise News sister publication, This Day Newspapers, on the worrisome court orders granted in favor of politicians engaged in forum shopping, to discuss the course of action taken by the CJN and determine if warning the heads of court will serve as a sufficient deterrent against the issuance of conflicting orders. We are now being joined by Professor Paul Ananaba. Professor Ananaba is a senior advocate of Nigeria and former chairman of the MBA section on public interest and development law. Welcome to the morning show, Professor Ananaba. Thank you for joining us. Good morning.
Thank you, Dr. Abati.
Good morning.
Good morning.
Well, very quickly, you had the introduction, the abuse of ex parte orders, despite practice directions that have been given in the past, despite rules of professional conduct now being wantonly violated by lawyers engaged in forum shopping, and the intervention of the Chief Justice of Nigeria. What are your views on all of this? And do you think that the steps taken by the Chief Justice of Nigeria will serve as any form of deterrence?
Thank you, Dr. Abati, and listeners and viewers. It's indeed shocking the way and manner the use of the ex parte orders are now playing out. Let me start with what is even an ex parte order. An ex parte order is a provision by the legal framework, particularly in Nigeria, where the law allows for a judge to address an urgent situation and arrest it. I'll give you a typical example. Because of the way people behave, organizations, even governments, we often have vacation periods in our courts. Like now, many courts are on vacation. You may suddenly see that a developer, for example, has a lot of money, he buys a property, shows up in the property and says, everyone in this house should pack out by tomorrow or next. And with the next morning, you are seeing bulldozers in the place. Residents can approach a court immediately for an ex parte order stopping such action. So in this small scenario, you will be seeing that there is an urgency. There will be irreparable damage because in the course of pulling down the premises or the building, many things that cannot be replaced may be lost. In the process of doing that, there may be riots, violence, and people may lose their lives, which are not replaceable. And the law weighs in and halts such carnage and problem. That's a typical ex parte order. So ex parte order is hearing just one party. The court hears one party because of urgency. There's no time to put the other party on notice. Before that can be done, an irreparable harm would have been done. Now, the Supreme Court has stated clearly, Nabiola and 7 of that, listen, ex parte orders are constitutional. Because the first issue that comes up is, why would a judge even hear one party and start making an order in the first place? I want to lay that down, that the Supreme Court has led it to rest that, no, it's not unconstitutional, and it is really true. It's not, because it is for cases of extreme challenge that the court comes in. Now, how do you bring that to political cases? That's where the problem is. Now, bringing it to political cases, as we have, for example, in the case of the chairmanship of the PDP, is unimaginable. There is no extreme danger of Uche Secondos being in the office as to warrant removing him by ex parte order. I don't see that. There is no urgency. So, in that case, the court ought to have put the other parties on notice. Now we have taken that. While we are considering whether ex parte order was appropriate in such political case, another court of coordinate jurisdiction now issues another ex parte order restoring the chairman of a PDP. That doesn't happen, because if an ex parte order is issued, the proper course of action is to bring an application to set it aside. If it was issued by the Federal High Court, once you file application to set the order aside, 14 days, if that order has not been set aside, it expires. Now, there could be cases of then appealing such judgment, and not for another set of litigants to go to a faraway state in the north, outside even the theater of this particular war, raising issue of forum shopping. In the first place, why will the Rivers Court, High Court, then issue such order? Where does the defendant, which is the chairman of the party, where does he reside? Where is the headquarters of a PDP? What grounds jurisdiction on Lagos and on Rivers High Court? And while that was also going on, another court again issues another ex parte order asking Uche Secondos to go back. Then you are looking at the judiciary, the judges, who knowingly issue such orders. Because, I mean, these orders, before they are even issued, or as soon as they are issued, they are public notice, they go viral. Every judge for which an ex parte application is brought in a same situation will warn himself before issuing any ex parte order. And if he issues such ex parte order, he will know that it will have consequences. And what about, did the judges file the motions? No.
Well, Prof.
They were filed by lawyers like me and other lawyers.
Prof.
And these lawyers knew also that there were existing orders.
Well, Prof, sorry to interrupt you at this point.
The profession should arise,
Prof,
both at the bench and at the bar. Let me round up by saying...
No, just a moment, Prof.
Yes?
We need to take a short break. When we return, then you can conclude. Please stay with us. We'll be right back. Welcome back to the morning show here on the Arise News channel. Professor Paul Ananaba is still our guest, Senior Advocate of Nigeria and former Chairman of the MBA section on Public Interest and Development Law. Well, thank you very much for staying with us, Professor Ananaba. You were going to conclude on the prefatory statements that you made.
Yes, what I was saying, thank you, Dr. Abati, is I just painted the picture, and I will look at the professional angles now. Now, the CJN now invites the six chief judges, brother judges. These judges, as chief judges, they are also called the heads of courts in those states. And I endorse the the action of the CJN. Maybe unknown to Nigeria and many people, why the CJN's role is so important and what role he has played is commendable. Now, discipline of these judges has to come from the NJC. But before the NJC acts, there has to be a petition. And while the NJC may be waiting for petition, the public will be saying that nothing has been done about this kind of unbecoming injunctions flying from different courts or different parts of the country. It got to a point that a cartoon went viral where a judge was saying, hawking injunctions, come and buy injunctions. And people were coming to buy and were going. So people the populace will be becoming impatient. So I think it was an elderly and a well thought out way by the CJN to call his brother judges, heads of courts, and say, why must this happen? And that gives and buys the confidence and the psychological content of Nigerians and even members of the bar that something is being done. And I understand is progressing to now inviting the judges that actually gave those orders. When the CJN took that step, it becomes difficult for NJC to wait for any formal petition because the CJN is the head of the NJC. And having taken that step, NJC is already in it. So I commend that, and I believe that pending when the procedure to report judges may be looked at again, that will be a good way to follow by this CJN and subsequent CJN. But at the bar, the NBA has risen to it. NBA must not allow this to go ordinarily because the NBA ought to, in my opinion, even invite the lawyers that file these applications to explain their roles. That is fair hearing. If they have no complicity in it, then NBA will decide that and know whether the disciplinary committee of the bar will set in. Now, these are important for these following reasons. June 10, 1993, an organization, ABN, Association of Better Nigerians, filed an application to halt an election. You will recall, I'm not talking about June 12, I'm talking about June 10. Justice Basi Beme delivered ex parte orders at a difficult time of the day and history of Nigeria. Nigerians may not have forgotten that. Again, June 15, Justice Saleh gave orders again on injunctions. Injunctions are good, but the way they are abused, contrary to the code of ethics of judges, is the problem, and we must tighten that. We must not allow this to just be wished away. Otherwise, 2023 will be in jeopardy because the politician will be willing to use the court in the wrong manner and will proceed to do it if judges and the legal profession and the NJC and the CJN and the Attorney General of the Federation do not step up and say, it must not happen. The judiciary and the lawyers must not be used to truncate democracy. Because when you could see where the country is today, the violence, the insecurity, you cannot remove the roles of tribunals, courts, lawyers in this. Because in some states, you will find that either the tribunal or the courts would have put in either the members of House of Assembly by virtue, or even the governors or all that. So, and this may not be the wish of the populace who voted. But for one technicality or the other, a man becomes your governor, or becomes your senator, or becomes your... So we should begin to look at these things holistically. We should begin to ensure that the last hope of the common man, the judiciary, the judges, play their roles with patriotism, nationalism, fairness, integrity, and all that goes with it. That's what the problem is. And the lawyers are not left out. The lawyers
No, they're not.
must be also patriotic. That's my position. Thank you.
Right, Professor. The CJN invited 7 chief judges to be grilled by him and escalated the matter with only 3 unnamed chief judges to the NJC. Why do you think that was? What do you think has managed to seemingly exonerate 4 chief judges and left only 3 judges to face sanctions? And also with the NBA, I know that you'll be moderating a panel next week on this very issue. What is that panel? What is the aim? What is it meant to achieve? And beyond, I imagine, educating your fellow lawyers, your learned colleagues, what sanctions will be imposed against lawyers that are found to have erred in this matter?
Well, your questions are just, I'll try to take them one after the other. What sanction? The Rules of Professional Conduct 2020 provides for what should be done. The lawyers the sanction may include striking out their names from the roll of lawyers. They no longer become lawyers. They can be demoted if they are senior advocates, or they can be suspended. They can be cautioned, and they can be set free if nothing is wrong. It's similar to the judges too. The judges could be dismissed, could be suspended, could, be cautioned and all that. Now, what is NBA doing? The NBA, through the section on public interest and development law, will be hosting a webinar on Tuesday, where we will have a retired Supreme Court judge, former chairman of, president of NBA, the current president of the NBA, and senior advocates of Nigeria and other activists speak about this issue in much detail. Then, and to raise the consciousness of the bar and bench as to the danger inherent in these conflicting orders, in this wrong use of the judicial system in one way or the other. I will be actually moderating that session. That is there. That is just to say that the NBA is not silent. That is being done to ensure that never again. We don't have that again, at least from the side of the bar and the bench. And we expect that political parties should now know that they shouldn't go to drag the judiciary and the bar into their problems. Political matters should actually get political solutions, except legal issues that touch on them, that should go to the courts. Now, the CJN had interaction with broader judges, broader heads of courts, and the discussion is not public. If after the discussion, the CJN has come up with saying, okay, we will interrogate further 3 judges, you would have known that the CJN didn't just come up from the air to only zero in on 3. It would have been a product of that discussion, and that product is not public. So I'm not in a position to say what they discussed, but it is prima facie evident that it is a well thought out move, because he had met with the broader heads of courts and have come to a conclusion, perhaps, that 3 judges should answer. And these heads of courts in the states are the ones that are in charge. Cases don't just fall on a judge. cases are assigned, it is these heads of courts that are in charge of having the administrative heads of divisions from which judges cases are assigned, so that in future political cases and all that will now have to be assigned carefully. And in many cases, the chief judges of those states may have to assume, sit on those cases to ensure that it is experienced judges and judges, not just experienced judges that understand the terrain, that should be assigned those types of cases. So I don't think we should worry about the three. And there's no law that says in the course of examining the three judges, whoever they may be, that there may not be need for other judges. Now, other heads of course across the country, 36 states and their city, would have now been seen that it is no longer business as usual. They may have to set out to put up practice directions now, fresh practice directions on ex parte applications and how they should be handled and what should be done.
Right, sir. Thank you so much for your insight, Prof. Prof, the big elephant in the room in all of this is corruption, probably money. And that's where I want to direct my question and ask you. I mean, how can we take money out of all of this? I know it will be difficult because on the part of the lawyers that are going shopping around the country from KB to Anambra to everywhere to get this injunction, the price is right. That's why you can get it 1 a.m. in the morning. And on the part of the judges too, the price is right. That's what will make a vacation judge come back and issue things like this and get the cut. And we all remember the case in this country, 2016, although a lot of people opposed it, when the DSS had this, Gestapo-style raid on judges. And they said they found $800,000 in the hands of some of these judges in this country. We all remember that incident. So how can we take money out of our judicial system? Because once money is in there, then there is no how. We'll have corruption. And this cries for, being the court being the hope for the common man, the last resort. It's just crocodile tears.
Thank you, my brother. Let me take it the way I perceive it. I cannot say that money is not at play. I cannot also say that money is at play. People do things for several reasons. The problem is failure of integrity before it even gets into corruption, full-blown. In some countries, I take Ghana for example, some journalists took it upon themselves to expose corruption in the judiciary, and not less than 30 judges were dismissed. And I have always said, before you take the first son of a community across that community in a disgraceful manner, you need to let the community know what their first son has done. I do not subscribe to the way the security agencies went in the wee hours and broke into the houses of judges. I do not subscribe to it. And at the end of the day, through the legal process, no single judge that was accosted in that manner was convicted. And then it now heightens the problem. It's giving back to this one we're having now. Security agencies should do their work within the law and properly, so that we can get those judges, those lawyers that are the back ends that are painting everybody black. That is the point. We should not, because we think money went into it, and then we go the wrong way. There was a time in this country, some years back, an election petition matter. Some justices of the Supreme Court of Appeal were sanctioned. They were sanctioned and properly, and nobody better than I, because it was properly done. They were investigated, that judgment was given, and the way that judgment was given, there was evidence that money moved into their places. And then the appropriate judicial process went on. This is not the first time judges are being sanctioned in this country, and it was well taken. But that to use that as excuse to break into houses of justice in the middle of the night, frighten them so that those who are courageous cannot also proceed to deliver courageous judgments even against the government is unacceptable. That on its own is a worse corruption, to my mind. What is right is all arms of government, all sections of society should kick into this fight against corruption. There is a whistleblower program. There is the journalist. You, the journalist, do some investigative journalism. There is the bar, MBA. Let's do our part too, beyond what we are doing now. There is the society. Is it not human beings that bring this money we are talking about? Are there no banks? Can there be marked money? Is there no technology to help to track the code of conduct, accounts verifications and all that? Don't we have BVN and all that today? Those should be done. What I do not subscribe to is a situation where we are using corruption to occasion injustice. I don't subscribe to that. But corruption, for what it is, should be fought frontally and totally.
Well, Prof, you know that this abuse of ex parte orders, as you yourself have indicated, is not new. Even as far back as 1985. It was the same issue that Justice Mohammed Bello, CJN as it then was dealing with. And yet, yes, judges have been sanctioned, lawyers have been sanctioned, but the practice continues. And the most disturbing part of it is that the lawyers involved in some of the recent cases, they are senior advocates of Nigeria, majorly. So could we presume that they don't know what the law is, or they don't know the rules of procedure, or that this is just a case of mischief or incompetence on their part? And I've also had lawyers argue that, look, PDP, for example, a political party, can be sued from any part of the country where the party has an office, and that begs the question of a jurisdiction. So what concrete measures can be put in place to check forum shopping? Because it's like, you know, lawyers themselves trying to game the system.
Well, this is not a courtroom, so I wouldn't be placing professional arguments on this. But the law is settled that you sue a party at its principal place of business. That's what the law is. In Milatankori's case, the Supreme Court was very clear. So, for those who argue, there's no argument. Dr. Parte, I'm sure you are versed with philosophy. There's no philosophy, no teaching that doesn't have adherents. Some people even believe that they fell from heaven down on earth and that they are everything there. So there are followers to that. So people can believe whatever they want. But this is hurting this country. And like I explained, ex parte orders that are meant for useful purposes is being used wrongly. don't be surprised that if nothing is done, that even by 2023, the elections can be stopped by expert orders. The elections, even the result can also be affected by that. And somebody just goes and says, because you can sue from anywhere, go to one remote area. That's what foreign shopping is all about. Applies, okay, stop the election at this point. Stop the collection of votes. And that is what I believe Arise Television and all that are bringing to the table to say, let's all fight this now. Let's fight it now. Let's stop it. And practice direction is helpful because we now have a practice direction that in election cases, no ex parte order should be made. Outlawing ex parte application in election cases. And further practice directions can be made in respect of any injunction whatsoever. And again, judges, there should be judges conference with this injunction, ex parte order, and election cases as a team. NBA should also, in the conferences, hold discussions around this because it is so important now. I remember Justice Bello in 1985. He got to a point, he issued a statement describing of judges without justice. It's a fine reading if you can lay your hands on that. Of judges without justice. Because that act then was just, if you issue ex parte orders in that manner, you are no longer doing justice. That's what Justice Bello was saying. That judges must be judges with justice and not judges without justice. That's the point. And so, you are asking me that some of the lawyers are senior advocates and not. In the legal profession, all lawyers are equal. The SN is a rank in terms of practice. Well, there's equality by our profession. We're all lawyers. What I mean is that there is no immunity to any lawyer allowing that lawyer to do what is wrong. You're asking me whether they know or they don't know. What I'm expressing is my position. I'm not acting in a judicial position. If there were colleagues who file those processes and all that, that's what I said, that it would be right to hear from them. Let them explain why a Port Harcourt High Court will issue an ex parte order. You will now go to Jigawa or KB or Cross River or any state whatsoever to get another, even when Milatankori's case is still in the law reports and has not been overruled or set aside. And I'll be surprised if any colleague will be saying he doesn't understand what forum shopping means. So let's all move forward better by ensuring that these ex parte orders, injunctions, election cases are not just decided without deep thought, without concern for the country, without patriotism. You could remember that it was judiciary in this country in 1979 when the Supreme Court had to decide Awo and Shagari's case as to 12 to 3rd states. If you read those judgments, you will see justice at play, and it brought peace and unity to this country, and that's what is expected going forward. Never again should we go back into this spate of orders, of course, of coordinate jurisdiction. If it were completing judgments of the Supreme Court or Court of Appeal, the law is settled in that, and then we go for the latest decision. But for courts of coordinate jurisdiction at the High Court level, it is It is not acceptable.
Well, on that note, we'd like to thank you very much, Professor Ananaba, for joining us on the morning show. Thank you very much indeed.